Okay, good evening, everybody. Welcome to the Planning Commission meeting on, what is today? September 4th. And I guess we will begin with roll call.
Dana.
Here.
Jones.
Here.
Sarmiento. Here. Beach Olson.
Here.
Rivera. Cammer.
Here. Item number 2, we'll go to the Pledge of Allegiance. Please stand. Once again, welcome back. I know we haven't had a meeting for a couple months, so I don't know, are we out of practice? Item number 3, presentations and oral communications from the public and the Planning Commission. This time is set aside for members of the general public to address the Planning Commission on any item not on the agenda, which is within the subject matter jurisdiction of the Planning Commission. No action or discussion shall be taken on any item presented, except that any commissioner may respond to statements made or questions asked, or may ask questions for clarification. All matters of an administrative nature will be referred to staff. All matters relating to Planning Commission will be noted in the minutes and may be scheduled for discussion at a future meeting or referred to staff for clarification and report. Any commissioner may place matters brought up under oral communications on a future agenda. All speakers are asked to fill out a card and leave it on the podium, announce their name and address in order to obtain an accurate record for the minutes. Do we have any oral communications from the public besides the presentation? Do I bring it back for the commission? Okay, do we have oral communications from the commission? Okay.
First of all, I hope everyone enjoyed a good Labor Day yesterday, and we would like to continue to recognize the dignity of labor and those who labor in the fields and working, and who have created a strong tradition of working for workers' rights and advocating for this valuable part of our community. And I also want to share that I was very pleased that so many members of the public attended the City Council meeting last week and spoke on behalf of both the brew pubs and the housing development. Both were two issues that we spent time discussing and ruling on here in Planning Commission. So it was good to see that the public took some interest in what we were doing and continued to follow it up to the council level.
Thank you. Anybody else? Commissioner Sarmiento.
I know that there were a lot of different activities that we had in the community. I think I've already said this before, but I would love to repeat it because the concert at the Plaza is an amazing event, and I really would like for us to continue having that event every year, and if possible to increase it maybe by 2 more concerts, and also the wine art and walk that we had. This whole year has been filled with different activities that the city has done to bring the community out together, and I think it's building more relationships, and it definitely feels good to be out there. Thank you.
Thank you. Commissioner Jones, Commissioner Dana? No? I have a couple things. This morning I attended a South County Bicycle Pedestrian Work Group. We meet every other month on Tuesday, the first Tuesday of the month, and it's an advocacy group for safe bicycling and pedestrian infrastructure and education. So there are 2 workshops coming up. The first one is called a Safe Streets Workshop, It takes place this Sunday, September 9th, from 2 to 5:30 p.m. It will be held at the PAL Police Activities League office. That is at 37 Davis Street, just off of Freedom Boulevard. And what they're going to be doing is they want to address the safety of Freedom Boulevard by presenting the community with possible bike and pedestrian improvements. There will be, there's food, you have to register in advance, or you can register when you get there, if you get there around 1:30. There'll be a walking audit of Freedom Boulevard, and a walking audit means that you will walk down Freedom Boulevard and point out different concerns or safety issues that you have seen on Freedom Boulevard. And the goal is to develop a report with recommendations to send on to city officials. The second one is a Safe Routes to School plan. And that is to create safe routes to 15 Watsonville schools so that students can bike or walk to their neighborhood school. There are 2 workshops. One is on Wednesday, September 26th. That will be at Starlight Elementary. And the second one will be the next day, Thursday, September 27th. That will be at EA Hall Middle School. Both are from 6:30 to 8:30 p.m. And the goal is to learn about the planning processes, to share concerns, to suggest ways to make walking or bicycling to local schools more safe, easier to do, and just more fun. So if anybody can attend those workshops, that would be really great to advocate for all of our residents to have more safe bicycling and pedestrian infrastructure. Thank you. Okay, City Attorney Alan Smith will now give a presentation, and it's this packet, is that correct? Okay.
You're correct. Thank you very much.
Thank you for being here.
On? Okay, great. So, first of all, thank you for allowing me to be here this evening. Susie asked me to come down. I haven't been here for a long time, and she asked me to talk about a couple subjects. The presentation tonight is going to be shallow and narrow because we have a limited amount of time, and there's a lot of material out there to cover. And I can come back at some future time and discuss some of these other issues, but just to start off with, we picked 5 issues that we want to talk about. It's a little difficult and it's not really your intimate teaching, learning session here with you folks way up there and me way back here, but we'll give it a shot. So the first test is whether the, first of all, I hope that's not one of Rick's listings.
Competitors? It's okay if it's me.
It was on the internet and I needed a house in Watsonville.
I know you blame
So
it, so
hopefully there's no issue there. Okay, so we have 5 topics tonight. Legislation versus adjudication. Those are the 2 things that you folks do and the city council does, and they have different rules that apply to them. We're going to spend a number of slides this evening discussing those things and why they're so important to differentiate. We're going to have a basic parliamentary procedure. We're going to talk a little bit about the chair, a little bit about the main motion, the motion to amend, and the substitute motion. That's all we're going to talk about on parliamentary procedure. So if anybody's planning on leaving, please give me a chance. We're going to keep it real short, real simple. We're going to talk about due process because that's an important issue. We'll talk about the famous wedding cake case in front of the Supreme Court that everybody thought was a huge thing about discrimination and all that sort of thing, but it was really a due process case. And we'll talk a little bit about that because you folks have to administer due process in your hearing just like the council does. We're going to talk about findings a little bit. We just had some great examples of findings, and actually also the 4th the last discussion. I have 2 3s there, I'm sorry. About findings, and we're going to use the Sunshine subdivision as an example of that and talk about those a little bit so that you can scrutinize those and understand those when the staff brings them to you in a way that's a little different than when you just get them as part of an application. So first thing, legislation and adjudication. So he's got the wrong slideshow in here. I'm going to have to do it a little differently. So I think we can do it anyway. So legislation is what you do when you affect a whole broad portion of the community. You affect the people over in District 1, same way you affect the people in District 2. Example of that might be a change in the residential zoning requirements. So what's a permitted use in residential applies across the whole city uniformly. Findings are generally not required for legislation, with a few exceptions. Some of the housing issues where the state legislature comes down and says, we want you to make findings because some cities were restricting the number of houses that could be built, and so they made a requirement that you have certain findings on housing. But generally speaking, the general plan, the zoning code amendments, and the CIP, the capital plan, are legislation. So you're painting a very broad picture. There's not as much room for mischief as to 1 or 2 individuals. The notice requirements are different, a lot of different requirements. So that's legislation. There's also judging. Judging, you're doing something a little bit different. That's Judge Burdick. Judge Burdick was the person who ruled on the first City of Watsonville general plan amendment, and so he and some of the other judges, he's not any different than any of the other ones, but those are the ones who are going to scrutinize what you do when you judge. So that's the audience, and of course the Court of Appeal above him. So findings are required for adjudication. They're the reasons the law requires that we give somebody who comes in as an applicant, when you make an administrative decision, such as a use permit or something like that, it's a statement of the standards, the facts, and the conclusions that you folks made as recommended by staff to a decision approving something or rejecting something. They're the city's written reasons for land use decisions, and they explain how the commission or the council processed the evidence presented to reach its decision. And the reason it's important for people to have that is that they know whether or not they want to challenge you. If they think that it's a reasonable decision and it's one that's compliant with the law, they're probably not going to challenge you. If they find a lawyer who will tell them that it is inconsistent with any one of those things, they may very well challenge you. So that's judging. So judging, narrow set of facts, 1, 2 people, 1 or 2 pieces of property that are involved. Legislation, the whole city generally is what is affected. Examples of adjudication, judging, are use permits for consistency with specific use permit requirements in the municipal code. We'll look at that in a little bit. Coastal development permits, local coastal plans, subdivision maps like Sunshine, consistent, we see, with the general plan, and variances are all examples of you exercising your judging role. Second subject, parliamentary procedure. So this stuff goes way back. We're talking to Greeks, and why? Because once the eternal tribal form of people managing their affairs went away, when the Greeks came and formed the first societies, that's when we first started to have groups of people living together, communications, and people wanted to have an orderly determination of their business. So it started way back in 750, and then the Romans swiped it, and they used it in the Forum, and then after them, the English got a hold of it. We had a long, dark period, as you know. The English got it. It came to the U.S. There was a informal 1789. The U.S. House had its rules of procedure It wasn't Parliament, but they had rules so that everybody knew what to do and what not to do. And then Jefferson Thomas wrote a manual of parliamentary procedure and practice for the Senate. And then the one everybody talks about, Robert's Rules. It's 1876. A Civil War officer came out. There were a lot of churches, a lot of community organizations, small towns that were forming across the country, and they were coming in and trying to figure out a way to conduct their affairs so that the majority, although they prevailed, the minority did not feel they were taken advantage of. So we began to have parliamentary procedure. In 1898, Mason wrote a book that's used by most legislatures yet today. Alice Sturgis wrote something called the Modern Parliamentary Procedure. I call it the Relaxed Rules of Order. It's used by LAFCO in Santa Cruz County. Gary Patton was instrumental in using that. It's a much more user-friendly book, but it's out there. And my personal favorite, Rosenberg's Rules, which he's actually a Superior Court judge, former mayor of, I think, Vacaville, and former Yolo County supervisor, who in his spare time is a student of parliamentary procedure, and he's got a 4 or 5 page set of rules out that the League of California Cities is promoting. He's also got a very good video out on Vimeo that you can watch. It's about an hour. I didn't bring it here tonight, but he sets forth the basic rules and how they work. And I'm going to swipe a couple pieces of what he has. So why do we have it? We establish order. It's dangerous for us to rely on what makes sense in the heat of the moment. We may have had a bad day. There may be somebody who's in the audience demanding something. We may not have time to think it through. It may not be comfortable to debate it. So we try to have some predictability. It brings clarity and simplicity, so no one is disadvantaged. We don't want the minority to be disadvantaged by the majority. We want them to have a right to speak and to be heard. Even though they don't know the rules, we want to keep it simple. We want to enforce, however, we want to enforce the rule of the majority, because we do have to conduct business and we do have to move on majority rules. And the net result is we hope it brings uniform and fair treatment to all. So that gets to the point of the chair, which I asked a little bit about. And chair is a very,
Now you tell me.
yeah, most of you know that
late.
I've been elected for 24 years of a educational board, and sat as a chair for, I think, 4 or 5 of those years. And being a chair is not easy for those of you who have done it. It's not easy for a couple reasons. One is you're trying to, you probably have your own ideas about where things could go, and you want to make your own arguments, but you have other people arguing too, and you're trying to, have the public speak. You want to have your own ideas out. You want to make sure everybody's recognized, everybody's treated fairly. It's stressful, to say the least. So a couple rules for chairs. Chair must understand the rules better than the members for the most part, or at least be aware of the ones that are likely to come up that night. The chair moves the meeting and the agenda at the correct pace, neither too fast nor too slow. We don't want the people to get bored or feel that you're not doing their business, but we don't want to go so fast that people feel left out. So there's a balance to be struck, and there is no hard and fast rule for that. It depends on the audience, and depends on the subject matter, and depends on your commission. The chair has to lead the process to make sure the rules are followed, because that's their role. So if Rick, for example, criticized Matthew for something that they did, and you're not following the rules, one of them may not take that well, but because it's not really their role in there, the chair should be doing that and saying, Rick, don't do this, or Matthew, don't do this, or whatever it happens to be. That's what the chair is supposed to be doing, because that way it doesn't upset Rick or upset Matthew. Not that they're not calm people, but it is upsetting in that context when you're trying to get your idea across to have the two of them going back and forth, and the chair's sitting there going, well, wait a second, what's going on here? So we try to have the chair be the enforcer. So therefore, as I said, the chair takes a less active role in the debate. Often find it works best to have the chair speak last. And there's a couple of reasons for that. One good reason is that chair may not have to speak because all the ideas may have been provided by the other members of the commission, and it may not be necessary. Another reason is that they may say it, but you can restate it. So you have an opportunity to emphasize something rather than get the idea out in the first place. Also, you get a sense as the chair at the end of where people are going. If you find that it's a 3-3 split, you may have a different reason for saying things as the chair than you do if it's a 6-1 or a 6-0 to that point. It's generally better for the chair while they're presiding not to be debating motions with other members, because you, as you rotate the chair through, rely upon the chair to direct your group of peers to make sure that you have somebody who you all agree is going to lead you through this path to get to a decision in a business-like way. So, first motion everybody talks about, and one you're most experienced with, is the main motion. So it'd be something like a motion at this time is in order. That might be invited by the chair, or it may be, and that's the way it's supposed to work, is that the chair recognizes you to make a motion. Now, it's very common in informal settings like city councils and planning commissions for people to just, raise their hand or just make the motion anyway, but the true way to do it is to have the chair recognize the person before they make the main motion. The second does not need to be recognized, so Rick may make a motion, Matthew may say, and after being recognized by the chair, and then Matthew could say, I second it. In order to get there, the way to get there is after the staff makes the presentation, after the consultant comes up, or whoever it happens to be, then the chair would ask the group, do you have questions? So we're not debating the points yet. We're asking if there are any questions, something that's unclear about staff or inadequate in the staff presentation. The board or commission would have an opportunity to ask questions before the debate even starts. Then, once that is concluded, it would go out typically to the public, and the public would have a chance to speak. And the reason that's good is, again, because the public may say things that may cause you to change your mind after you. So if you say what your position is before you hear the public, sometimes that's not as effective as listening to the public first and see what they say. They may have some really good ideas. You never know. And so by just asking your questions and then clarifying things that are important to you and then putting out to the public, letting them speak, and then coming back to you, you can have a more effective debate, and you get a sense of where the public is, if the public is active on a particular matter. So you say, I move, you get recognized, somebody makes a motion to second. At that point, you got a motion, recognized by the chair, a second, then you have debate. So the chair would recognize somebody. I like to speak to the motion. Usually it's the person who made the motion, doesn't have to be. So you speak about the motion, and then somebody else is recognized, and they speak about the motion. And maybe it's just two of you, maybe it's all of you, and the chair recognizes you and you speak about the motion. So you have the debate at that point. So you've had the staff presentation, you've had the questions, you've had out in the public, if anything, you've come back to yourself, you've had a motion, you've had a second focusing things, because maybe the staff recommendation is not going to be the motion. Maybe you'll decide it's going to be something else. That'll be the discussion. So you make the motion, have the second, then you have the debate amongst yourselves.
I have a quick question.
Yes, sir.
So last month when this happened to us, in case this happens again, so there was a motion made, and during the discussion, apparently amendments were added to the original motion. So I'm thinking, shouldn't we vote at that point on each amendment to the motion? Because
Next
we
slide.
were, next, okay, I'm sorry.
Right there. Motion to amend.
Sorry.
You get there.
Should've waited one
These are
slide.
these are the most popular questions, I assure you.
Gotcha.
And so it's good. It's good. You're showing your interest. I was a little worried there, so thank you. Appreciate it, Rick. I didn't ask him to ask that question. It was spontaneous.
Yes, it was.
Alan, can I ask a question? So can you go through I want to make sure that we're doing things properly. So we'd have the staff presentation, and then we'd bring it back to the commission for questions of staff, clarification questions. And then after that, it's the public comes up and speaks. And then after that, we have a
Comes back to you,
okay, and a
and you could
discussion.
say, do we have a motion?
Okay, so after the public, there's a possibility of having a motion.
Yes.
Okay,
Yeah.
okay, without discussion, okay.
I just want to make sure everybody realizes, this is not like a traffic infraction. If you violate the rules of Robert's rules, nobody's going to issue you a citation, and you're going to get to the right result eventually anyway, probably. This is just a way to try to have everybody, it's like, going to somebody's house and having manners, you kind of, if you learn your manners about, which fork to use, then you feel more comfortable because everybody knows what the rules are. And that's what parliamentary procedure is just to be comfortable, not get a citation because you brought it the wrong way. So we get there the same way anyway. This is a way that I have found that works and is fairly consistent with Robert's rules, and Rosenberg, my favorite.
Okay, so, and then possibility of a motion, and then we bring it back to discuss the motion?
Right, you
Among
make
us?
a motion in a second, and then you.
Motion and second.
Motion in a second, and then the motion's on the floor.
Okay,
And then you, as the chair, say, would anybody like to speak to the motion? Or somebody may have raised their hand already. Matt raises his hand. Matt, would you like to speak to the motion? Or would you like to say something? Or your comments, whatever you want to say. And then Matt speaks, and then that may prompt Rick to disagree with him. Or Rick may say, me too, or whatever it happens to be. You don't know. And that goes on. You're watching it. You're not speaking yet under my proposal. And everybody gets kind of finished talking. And you may say, hey, I don't need to add anything. Or you may say, hey, now they're finished. I want to throw a grenade in, or I want to affirm everything, or I want to summarize, or whatever it is you want to do
okay.
after they've spoken. And so you're a little more relaxed as the chair at that point because they've done what they needed to do, and the debate has been formed up. You got a motion on the table and a second. And or on the other hand, you could say, as everybody's spoken, okay, I'd like to make a roll call or make a call for a vote if you've finished your debate.
Okay, and then we're going to go to what Rick asked, because that would be the next slide.
Well, we'll get to that slide in a minute. I promise you. So, use my example. The motion might be, I move we establish a 2-member committee to review the possible amendments to the general plan. And let's say Rick makes that motion. It gets a second, so it's being debated. Along comes Matt. He says, I think 2 is not enough. I think we ought to have 3. I'd like to amend that motion. I'd like to change Rick's motion, and instead of 2, I want it to be 3. So Rick says, well, first of all, the motions to amend, they add to or subtract from the main motion. The main motion's still sitting back there waiting to be acted upon, but you've then taken it one step further and you say, I want to change that. So somebody's coming along, raised their hand. Rick says, thank you, Anna, for recognizing me. I can make a motion. We change it from 2 to 3. And Matt seconds that. So now we have a motion to amend to move it from 2 members to 3 members. Debate that. Then you call the question. And if the motion passes, you're back to the main motion. Or if it fails, you're back to the motion. If it passes, you're back to the main motion and it's 3 people. If it fails, you're back to the main motion, it's 2 people. Then you vote on the main motion because your motion to amend has gone away. Does that make sense?
So what happened was the person motion didn't accept the amendment.
No. You're into the friendly amendment stuff. We
Oh,
don't,
okay.
We don't do friendly amendments here.
Okay, but that's what happened,
No,
right?
no,
Like
no,
I,
no, because
You can vote
the
on
person who made the motion, person that made the motion doesn't have to accept anything. Let me give you an example. Rick says, I make a motion that we have 2. Matt says, he seconds it, so we have a motion on the table. Then along comes Jenny, and Jenny says, I make a motion to be 3. And you, Jenny, say, well, I second that motion, so now we have a motion for 3. They don't like your motion, but there's not a damn thing you can do about it.
ooh, so we
because
didn't do
it's
that
his
right.
motion.
We
Except
didn't
vote
do that
against it.
right
It's your
then.
motion to change what he's doing. It's your motion. We're going to have one more motion, and we'll be done with motions here in a second.
Okay, I like
But-
what he's saying. Not what happened.
But that friendly amendment stuff gets into, everybody kind of looking at each other, the chair's out of the picture. You're not supposed to be asking the other person about the motion. The chair's running the meeting, not the other people.
Okay.
And it gets really
Yeah,
confusing.
yeah. No, it did.
It's used, and it's used by a lot of places, but it really, it's a mess, and it's a mess for Deborah too, because she's trying to figure out what the darn motion is. What is, I made a friendly one, well, what if it was an unfriendly one, But anyway,
Okay,
you
so
make
that was my
you make
mistake.
no, it's not a mistake, it's just a different way of doing it.
Yeah. No, it was a
So
mistake.
it's more organized, easier to track, and brings more clarity. If you make the main motion, get it on the table, somebody makes a motion to amend it, that motion passes, in which case it's changed, even if Rick doesn't like it, or it fails, in which case
Yeah.
Rick likes it.
So what we did wrong was the original motion came on, and then somebody wanted to adjust the time of closing of that motion. So we should have immediately went to a vote on that time, right? Right away. We
But
should have
if I
decided.
understand you correctly, you said you've got, somebody
It
made
was
a
an
motion
amendment, I'm
to close it at a time certain,
Right.
and you had a second on that, and so you had that motion on the table.
Which was the original motion.
Okay,
The
okay,
amendment.
So it's there.
Yeah.
So then somebody came along and says, I want to change the time. So I make a motion, we change the time from 10 to 11. And then that person, whoever it was, anybody could make a second to that motion.
Right.
And then you vote on that.
On that.
So you
On
vote
that,
on the amendment.
10 versus 11. That's
Yeah,
all
I
you-
voted against the whole project
Oh, okay.
because.
I don't wanna get into the details.
Exactly, but that's the point. That's what happens. You
So-
get stuck with stuff.
So you're changing it from just the time. It's the only thing that's changing. Main motion is going from 10 to 11 or 11 to 10. Then it comes back to the main motion. And the main motion is either 10 or it's 11.
Right.
If it's either way,
We go back to that.
she says, I call a vote.
Got it.
You vote on 10, you vote 11. It fails. So then somebody makes a new motion,
New
not an
motion,
amended motion, a new main motion.
Right.
And you're off and running.
Perfect.
And can the chair call for a vote at any moment, or does the chair usually have to wait for discussion to happen?
A chair can do that. It gets into somebody calling point of order, because you're not supposed to do that. But again, there's no police here, so, people may say, I think Matt's right. We've had enough talk about this, so they don't do anything. But you can.
Okay.
So
Okay.
can we go back to that, because I want to make sure that I want to make sure I do this right. So we have a motion on the table. Let's say the closing time is 10 o'clock. Somebody seconds that. Then somebody else makes a motion to have the time extended to 11
You make a
o'clock.
motion to amend the main
To
motion.
amend, okay, so it's a motion to amend
Amend the main motion.
the main motion, okay, and then.
What are they changing? They're changing from 10 into 11.
Okay,
There's a second on that amendment.
and then a call for a
Then
vote?
you call for a vote on
the
that amendment.
amendment,
If
okay.
that amendment passes and 4 of you vote 11, then it comes back to the main motion, and you're
Now been
voting on
amended.
whether it should, the whole motion, including
wait,
the
wait.
11 o'clock.
Say that
motions
again?
now.
Say the last part again?
In other words, the motion that, Rick's example is, I assume it was some sort of alcohol establishment or
Yeah.
something.
Yeah.
So I make a motion that we approve this proposal for alcohol establishments and that the closing time be 10. Let's say that's a motion, okay? Second, motion's up for debate. Along comes Jenny Sarmiento. She says, I like your motion, except I think it should be 11. So she makes a motion to amend the main motion, to change what Rick did from 10 to 11. She gets a second from second Jenny. Then the 7 of you vote. You say, I'm in favor of 11. And if there's 4 votes that says it's 11, then it comes back to the main motion, which is Rick's motion, except it's 11 instead of 10.
Oh, they
Despite Rick
substitute,
not
it
liking that.
changes. Okay, got it.
Despite Rick not liking that because you're amending his motion.
And then it goes back to another vote at that point?
Well,
Or-
you're in the main motion.
Still voting
and
on the main
You're going to vote on the main
motion.
motion.
Okay, okay.
Unless there's
All right,
any
so
other
it's only-
amendments offered, which after the first one fails, then Jenny can come up with something else and say,
can
hell,
have
we
an
lost
unlimited
another
I don't want to
number
go
of
there.
votes based on the
It
number
gets,
of
it goes
amendments.
on, and there's a motion to amend the amendment. I don't want to get into that. We're going to try to keep it real simple tonight, but you get the concept.
Yes.
Motion, amendment of the main motion, back to the main motion, vote on the main motion fails, a new main motion. Whatever it happens to be. I think we should have one alcohol establishment. It should be on Main Street, and it should close at 6 p.m. That's the new motion. Second for that one, goes on like that. But that way there's clarity, and Deborah can keep up with what the motion is and what the amendments are. Okay?
So when someone makes sorry about this, but this is what happened. I mean, when someone makes an amendment to a main motion, it should be one part of that main motion, not, because what happened was
It is,
was
because
two
that's the
things,
next, that's
right,
the
or
next
three things?
slide.
Okay.
Yeah, we should have voted
Substitute
on them
motion.
individually.
That's what
We're talking about substitute motions. That's what you're asking about, I think.
okay.
Okay?
All right.
So we've just had a main motion, had a motion to amend the main motion. Could have a motion to substitute a new motion in place of the one that you don't like. With me? So Rick's 10 o'clock, second at 10 o'clock, and somebody says, I think that's crazy. I think I make a motion that we deny staff recommendation and we don't have an alcohol ordinance or whatever it was. So, and we get Matt agrees, I agree with Rick, and so the motion on the floor is a substitute for the main motion. It replaces it. And you vote on that. Replaces the main motion. It's hard to get the substitute motions because they just take everything away the main motion had.
Also, I think the other piece is we had three things happen to a main motion that were just hard to keep track of because it started out with changing time and then changing the number of and then changing, and each one should have been voted on as a separate amendment to the main, always feeding back to the main, and then so we can have multiple votes
Yep.
on each amendment though. So what we need to make sure of, I guess, is that each time someone wants to amend a main, we make sure we stay focused on that one piece, vote on it, and then move to the next suggestion for the
Move
next
back,
amendment.
Yeah, exactly, yeah. Yeah, you could have had on Rick's deal, you could have had motion to approve the staff recommendation at 10, second goes to a amendment to the motion at 11, 11 fails, somebody makes a second amendment, motion to amend at 10:30.
Or midnight.
Or midnight.
Or even
Or
then
whatever, yeah.
completely second amendment or another amendment, sorry, not second amendment, another amendment that says, okay, now that we've discussed the time and we've agreed that it's 10 to, it's going to be a 10, now we're making another amendment that says now we want to limit the number of establishments from 7 to 5 or 5 to 7. And now we have that discussion, we vote on that amendment, and if it does pass or fail, it either adjusts or doesn't adjust the main motion, and then we're still back to the main motion.
Exactly.
then we fill the boat with so much stuff, by the time we get to the original motion.
Nobody can remember what
Then
the
maybe
original-
we won't even like it anymore because there's been so many amendments.
But then that's
that
when you
half
get your
of us-
substitute.
But
Well,
see,
that's
fair.
what happens.
That's when you
There's-
get back to the
see,
substitute,
but-
if that's where
but-
to be the case.
So Matt's point is a good point, because you take in these different subject matters to get there. Otherwise, somebody might say, I have a friendly amendment. If we make it 11, and I'd approve it, but only 5.
Right.
Then,
Which is exactly what happened.
so what's the motion?
Which is, I wanted 11, but I only want 5 of them.
Yeah.
Well, which
But
one
I
are we
think
on?
it's also the way that it's written on the recommendation, listening to you, I wish I had heard you a year ago when I was chair. Because when I read the recommendation, I read the whole entire thing. I don't break it down because I didn't know that I could break it down.
Well, no, I'm not saying you break it down.
No, but we could do that if it
Well,
has.
okay, that's a whole different situation. So you
Okay.
would, it's called a motion to divide the question. And, we could get into a lot of different motions here, but I just want to keep it
Simple.
peel the onion. Let's just try to get this stuff done tonight. I can come back at a different time and talk about something that's of interest to you folks. But typically you'd have a staff recommendation, and you'd either move the staff recommendation, or you'd start off with something slightly different than a staff recommendation, based on what you decided and what your questions and what the public said. But you move a staff recommendation, you don't start off with their long motion and you pick pieces of it off, because it's not a motion yet. So Rick says, I move staff recommendation, which is 10 and 5. So so it's a second, start a debate. During the debate, you say, I'm okay with 5, but I want it at 11 p.m. Motion to amend. Jenny says, okay, so it becomes a motion to amend at 11. So it goes back to what Susie had at the very beginning, but 11 instead of 10. Make sense? But we don't divide up the motion and take staff recommendation and break it apart into pieces, unless there are like 3 separate resolutions, and that might be appropriate. They could be interdependent, but it might be appropriate. But you take the staff recommendation to either approve it or reject it. That's a good place to start. Jenny?
I was just going to say, I think that is what happened a little bit with the Sunshine Vista housing development when Matt Huffaker said, so what you could do tonight is you could certify the EIR and then do these other things in this other way, rather than simply moving literally making a motion for the entire project and everything else that went along with it. And
Well, Matt had a reason for doing that.
Yeah.
If you certify the EIR and you post the notice of determination,
Right.
it starts the 30 days running and gets everything moving along the line.
Right.
So that's what he was trying to achieve.
yeah,
But that's what I was describing as, there were like, what, 3
Exactly.
ordinances
Yeah.
and 2 resos that
yep,
night?
yeah,
So that's why I say it's possible I move 1, 2, 3, in that case, the EIR was number 1, so I move to approve staff recommendation of number 1 and defer 2, 3, 4, 5
Right.
to the next meeting, something like that.
yeah, and then they didn't go with that.
But that's not what you run into most of the time. You don't have that many projects with that many moving parts in it.
Yeah.
Okay, so in my hypothetical substitute motion, we start off with 2 people to study it, motion to amend, move it to 3 people to study it, and then a motion to, instead of studying it, to defer review for a year would be a substitute motion. Okay, due process. All done. Good, we survived. So due process is really complicated, and I want to talk just about a few subjects, and there's going to be some of this stuff that you're experience and your practice and what we do here are going to be perhaps different. And I want to tell you, if it is different, why it's different to what I'm saying. And just because I say it here, I'm not like telling you. It's talking about sometimes best practices as opposed to somebody coming to get you if you don't do the right thing. So the first thing I want to talk about is due process. And that means, due process means notice and an opportunity to be heard. We want people who have in their property rights affected, if that's going to happen, to get notice from the government that that's happening and an opportunity to to speak to it at a fair hearing. That's what due process is. We have a whole scale of due process, you know. Due process when you're going to be executed for murdering somebody is really significant. You get a free lawyer, you get an automatic appeal, you get all kinds of stuff. Due process when you get a parking ticket is a phone call perhaps, an opportunity to contact them and maybe even go to an administrative hearing officer. So no free lawyer, no right to appeal, all that kind of stuff. So there's depending on the seriousness of the property right that's taken, you get more due process or less due process. So let's talk about planning commissions and city council. So we know Gil Garcetti, I think it's Gil, is the mayor of Los Angeles, and in 2017 he made a ruling that prohibited planning commissioners in Los Angeles County from speaking to developers except at the planning commission hearing. And some of you have had experience with the California Coastal Commission about ex parte communications. They actually have a process during the Coastal Commission hearing where they have ex parte disclosures. And so years ago when we did the high school and we were down at the Coastal Commission, you'd have somebody from Los Angeles coming in and they said, you know, I'm Commissioner, I'm Matt Jones, and I spoke with Barbara Streisand and whoever regarding their coastal development. We had lunch together on Barbara's porch, and she was concerned about her slope, and she wanted to put a retaining wall in, and it was an hour-and-a-half long lunch, and we talked about the soils conditions, we talked about this, and so-and-so was present. That's the ex parte disclosure that is required by the California Coastal Commission. Coastal Commission deals with big money projects. You're on the coast, big stuff. That's kind of filtering down into other agencies now. Garcetti in Los Angeles said that there's too much room for mischief with developers and planning commissioners or city council members for that matter, although, and remember, he's a strong mayor, so he can do a lot of stuff that you can't do in the smaller cities. But he said no more meetings with developers, no ex parte communications. So couple of slides missing. So anyway, the idea is that somebody who comes to a hearing is entitled to have a hearing where they hear all the evidence and it's decided by the person, or excuse me, you hear all the evidence and you decide it based on the evidence that they also hear. So if Rick comes to the hearing and he's been out at the subdivision and he has been, you know, squired around by the soils engineer and everybody else, and they went out to a lunch and they did all kinds of other things, and then they come back to the hearing and he's been persuaded because there's 5 of them and 1 of him, and, you know, they're, whatever they're going to do to convince him of something. The person whose property is affected is entitled to know about that. That's part of due process. They're entitled to be able to say, hey, Rick, you know, why didn't you talk to my soils engineer? Or why didn't you let me speak to you about that? I didn't know until the hearing tonight that you had all these communications, and how can I respond to that? I would have had my soils engineer, he's just down the street, but I didn't know you talked to them. It's not a fair hearing. So part of the process is ex parte communications, lack thereof. The best practice, it's not illegal to do it. I think the better practice is to disclose it. Simple way. You have those communications so that everybody knows why you're making a decision, including the other commissioners who say, God, I don't know why Rick did that. Why is he voting that way? It doesn't make any sense. Well, we all heard the same evidence here tonight, but Rick's going that way and we're all going this way. It may be because Rick has information that the rest of you don't. So, no ex parte communications.
Can I ask a quick question on
Yes,
that?
sir.
So if we have a call from somebody, a developer, anybody, a homeowner, somebody that's going to be coming up, and they want to just go over what the situation is sort of a briefing. There's no lunch, there's nothing like that. It's simply a educational, go out, look at the property, and see what the situation is. Should we not do that?
I think the best practice, Susie, I'd be interested in her take on this, but my opinion is the best practice is to not do that.
Okay.
To have the information presented in a public hearing where the applicant and the other commissioners hear the same thing. Susie? Quick.
Yeah, I'm sitting here thinking about it. Sorry. As you know, I've always offered before a hearing or before anything, maybe controversial that you might have questions about comes up. I always recommend that if you have questions, please call, because as planners, we're trained to give the facts without bias. So I would recommend I'm doing that. But aside from that, what I would recommend, if you're going to investigate and speak with a developer, you should speak with all other sides.
So if we had somebody like, for instance, on Sun Vista that asked us to come out and see the terrain and know what it actually looks like, so if we had any questions about, because it's difficult here and it's difficult to get onto that property, it's difficult to know what's being done there environmentally. So it was more, I looked at it, I rarely do that actually. You have to almost beg me to go see it. But in this case, I went, and I went for educational. It wasn't a matter of anything other than seeing the terrain and learning the project. So
I get
yeah.
that, and I wouldn't mean to suggest that it would be anything.
No, I just want to know if I should or shouldn't do that.
Other than that would
Yeah.
lead to your collective concurrence. So you see the terrain. The other 6 have not seen the terrain. Why doesn't
were
Rick
all
think the
invited.
terrain's a big deal? So Rick discloses, I went out and I looked at terrain. That's why I don't think it's a big deal. See, it's not lunch. That's the financial part, your gift limits and all that stuff. But I'm just talking about everybody having the same information and the applicant knowing what information you have to make your decision. Another version of that is that okay, I don't want to get too far afield. So
I get it.
Can I ask just a follow-up on that one? What if you, on your own, go and take a look at the property? For instance, when we had the Rodriguez property, I drove by there because I had seen that building and I wanted to get a better picture of what it was. I didn't meet with the developer before, but I had met with him years before when there was another property. But this time, I just drove by to look at it. Is
Well,
that?
That's fine,
so it's a much less material matter. We all live in a town that's 6 square miles, and it's really hard not to drive by stuff. You have to kind of avoid it, and it's your natural curiosity if they're doing something somewhere, if they're doing sunshine, and you're going, well, I got to go over the riverside, and I'm at Target. Why not just go that way, And so you got to get a sense of what the stuff's like. I don't think that's a big deal, but if you're going out and visiting the property, and then a neighbor pokes his head or her head over the fence and says, hey, I hate this thing, then it can snowball. So you just have to use your good judgment. Knowing the normal things that you'd know as a resident of the town and a knowledgeable resident of Watsonville, I don't think are a problem. But, getting out of the car and poking around, looking for drain holes, bringing some kind of a instrument along to measure the slope or something like that can get a little crazy. But just kind of looking at stuff I don't think is a big deal. Okay, due process. So I want to talk a bit about the cake case, Masterpiece Cake Shop. We all remember that case. That's the case where the two individuals went to the cake shop and they said, we want you to make a wedding cake for us. And he said, no, it's against my religion, I think is what he said. I'm not going to do it. And the Colorado Civil Rights Division conducted an investigation. They found that he had violated the law, and so they prosecuted him, and he appealed and challenged him, and it all the way up to the United States Supreme Court. So I don't want to get into the religion parts of it or the First Amendment parts of it so much, but that case was decided really on bias. We're going to poke at it a little bit. So first of all, let's talk about the case a little bit. That's the owner of the cake shop, Phillips. He turned away potential customers because of their sexual orientation. He said he could not create a cake for a same-sex wedding because his religious beliefs prohibited it and because the customers were doing something illegal in his mind at that time. The Civil Rights Division found the cake shop had a policy of not selling baked goods, it's important now, to same-sex couples, not just cakes. Based on the findings, the division found probable cause that he violated the law, and so they went all the way up to the Supreme Court. The Supreme Court said that the Civil Rights Commission's treatment of the case have some elements of a clear and impermissible hostility towards the sincere religious beliefs that he had. So he's going in there and saying, I have a strongly held religious belief in this regard. And the hostility of that commission, which could happen at a planning commission if you didn't like the project or if you didn't like the people or you didn't like development at all or whatever it happened to be, that hostility has to be, got to put it away. They said that it showed up in the public hearings, and from the transcript of the hearing where this person was being prosecuted, it says freedom of religion, and religion has been used to justify, this is the commissioner talking, used to justify all kinds of discrimination throughout history, whether it be slavery, whether it be the Holocaust, whether it be, we can list hundreds of situations where freedom of religion has been used to justify discrimination. And to me, it's one of the most despicable pieces of rhetoric that people can use, to use a religion to hurt others, meaning the people who wanted to buy the cake. And then they went on to describe a man's faith as one of the most despicable pieces, they're talking about the cake baker now, one of the most despicable pieces of rhetoric that people can use to disparage his religion in at least two distinct ways, by describing it as despicable and by characterizing it as merely rhetorical. This is the Supreme Court talking about their problem with the way that those individuals were treated by that mission in Colorado. And the court said, for these reasons, the court cannot avoid the conclusion that these statements cast doubt on the fairness and impartiality of the commission's decision of Phillips' case. So they're acting as judges here, right, like a use permit. And he felt that they were being, Supreme Court said that they were being, they were prejudiced, they were biased. And they were biased in such a way that it caused them to make a decision that was infirm in some way. By way of comparison, the Supreme Court said on at least 3 other occasions, the same Civil Rights Division considered the refusal of other bakers to create cakes with images that conveyed disapproval of same-sex marriage, along with religious text. Each time the division found that those bakers acted lawfully in refusing service and made the determinations because, in the words of the division, the cake had words and images deemed derogatory. So bias there, deemed hateful, that's okay, or deemed discriminatory. The division found no violation in the other cases, in part because each bakery was willing to sell other products, including Christian-themed ones, to the customers. But the commission dismissed Philip's willingness to sell. He would sell things to them too, just not the wedding cake. But they dismissed that. They said, we don't care about that, even though it was important in the other cases. So he was treated unfairly. That's why that went to the Supreme Court. Why the Colorado Civil Rights Division lost that case. Fairness, due process, everybody needs fair hearing. Findings. So these are really a big deal in use permits, any kind of adjudication, variances, subdivision maps, all that type of thing. You have a broad policy that you've legislated, that council's legislated, and you're applying the facts to see whether they fit into the slots so that you can make the findings to support the decision. And this takes an extraordinary amount of time for staff to work through these findings because there's a lot of them. And each decision often requires its own findings because it has its own requirements. It's a big deal. So it provides a framework for making principal decisions. So the reason that it's a framework is that to find out what findings you have to make, you go to the municipal code and go. That support and satisfy these requirements that have been legislated. So you're acting like a judge. Have you ever been in a jury and you've had jury instructions? That's sort of what findings are similar to. It facilitates orderly analysis and allows the public to see and understand that the decision is carefully reasoned and fair to all, because all you're doing is taking the facts of the particular situation, that particular subdivision, and applying to the subdivision ordinance. That's what you're doing. Not a lot of discretion there. It's either there or it's not there. And Susie will tell you sometimes that they really don't have any choice. I mean, it's a piece of land. It's zoned R residential. So can you put in a warehouse? Probably not. Can you put in a house? Pretty easy. Allows parties to understand whether and what basis they should seek review, because if you make findings that are not satisfied by the record, there's no facts to back up your findings, then they're gonna challenge you. If you make the findings to support it, much less likely they're gonna challenge you. And it allows the reviewing court, Judge Burdick, for example, to review the reason for the city's decision, whatever it happens to be. So let's just give an example. You look in and it's a dog, this is not Watsonville, but let's say you have a dog park ordinance in the zoning code. It says dog park will not result in a nuisance or enforcement problem within the neighborhood. That's the finding you have to make. Now, fast finding might be that the dog park is okay because it will not result in a nuisance or enforcement problem within the neighborhood. Doesn't really help that much. But look what they did here. They said the dog park will not result in an enforcement problem. That's the trigger. Because why? It's isolated. That's one reason. It's not part of an existing neighborhood, so it's going to be remote a little bit. Nearest residence is 2,000 feet away from the dog park, so they're not going to be bothered too much. The police department has reviewed it, and they require as mitigation a security system with cameras and operating hours so nobody will violate it. And the Parks Department will maintain the play areas and parking lot on a weekly basis and pick up waste. So there's not likely to be a nuisance. Those are good findings. That's what a finding is. You see them all the time. And so you need a record to support those findings. And the record is, and that's what you get your packet. That's in the staff reports. That's part of the findings, or excuse me, part of the record. The findings are part of the record. Conditions we'll talk about in a second. They're part of the record. Experts or consultants' reports, whether writing or in person, they're part of the record. And oral statements or writings submitted before or during the hearing are part of the record, whether they be by the applicant, by public, or by staff. All that, when you go up to the Superior Court, if they challenge a decision here, everything that's said in this hearing is prepared into a transcript, and it's in a booklet, and that goes to the court, and the court reads every hem and haw and ah and whatever it happens to be that comes out of a person's mouth is read there, along with all the paperwork. The staff report, anything was presented at the hearing, letters that come in, any of that stuff is a part of the record. Findings are necessary when it's not legislative. You're not adopting a zoning ordinance, when you're not adopting a general plan. That's when findings are required. You don't always see them, but you do see them. A lot of the work that you do. There are specific findings required when a general plan limits the housing. I talked about that before. They're required when approving and denying projects. And must demonstrate that the condition has a rough functionality to the development's impact. Okay, when are they not necessary? The other corollary is they're not necessary, for the most part, for legislative acts. If you're recommending a zoning ordinance change to the council, your findings are either non-existent or very, very short. So let's go back to the use permit that I talked about again. I talked with Susie about A, B, C, D, E, F, G. Those are the use permit findings that have to be made. And so I highlighted the three I want to talk about, and I want to take each of them separately. So Sunshine Vista got an SUP. See number two, if the proposed use development is compatible. The B, compatible with the preserved's character. So what I'm trying to do is to show you how staff took B and made a finding by putting all that stuff that's up there on that overhead together to support B. They said, supportive evidence. The project involves cleanup of a contaminated site, making it suitable for housing, junk vehicles, it's been removed, so on and so forth. That tends to preserve the character and integrity of nearby development. So they go through this whole process, which is extremely time-consuming and tedious and difficult to support their decision. C. So the second one I want to talk about is C there, that it not generate pedestrian or vehicular traffic. We had a lot of talk about that night with Sunshine. So the finding for the SUP, not generate pedestrian or vehicular traffic which will be hazardous or conflict with the existing and anticipated traffic in the neighborhood. So that's C. We go over here. How did they make that finding? It will not generate the traffic, the evidence. An EIR was prepared for the proposed project, which includes a traffic study. Traffic-related impacts were found to be potentially significant but mitigatable to less than significant levels. Measures that mitigate those are the intersection studies and a variety of other things to support that finding about traffic. Third one is the proposed sub of that this G in the SUP finding requirement. That the would not be materially detrimental to the public health, safety, convenience, and welfare, et cetera. And the evidence was the project involves the cleanup of a contaminated site, making it suitable for housing. Junk vehicles have been removed, so on and so forth. So those are that's the findings they have to make. And you can ask questions, and a lot of times when you're opposing a project as a commission, on those findings, opposing it, say, hey, I think it's worse. It's going to be worse afterwards. They're not taking all the junk off. They're not really removing the cars. Or I think it's so great they're removing the cars. I want to focus on that finding. So you can advance your view of things by focusing on the findings. Let's use another discussion about the Legislative Act, which has very abbreviated findings. And the one I'll use is from the same night, the brew pub. So this is all the findings. You know, when we had the findings for the subdivision, they were like about 30 pages. That's the entire findings for the Legislative Act, because it affected a wide variety of properties rather than an individual. So very relaxed findings. But they did make them. They said that the amendment's compatible to the extent possible with the general and actual planned use of the properties because the ordinance reduces the potential for nuisances. These are really the only requirements. Last one, conditions. What are conditions that are requirements that we place on a discretionary project that would make the project infeasible? Were they not there? They accommodate the project. For example, we'll get some examples here in a minute. They may include requirements enforced by people other than Watsonville. They may be requirements imposed by the Coastal Commission, by the airport, by a lot of it, or by the county, by a lot of people. And they must be consistent with federal, state, and local laws. So there's a couple of famous cases out there that tie into conditions, and you probably heard them from staff before. There's Nolan, Dolan, and one called Kuntz, a more recent one. And Nolan's was one in Ventura where the Nolans had imposed upon them by the Coastal Commission a public easement across their rural property as a condition for granting a land use permit, and they argued that was unconstitutional taking for which the state must pay. And they said, we don't think it's connected. And in those days, in Ventura County, there was nobody for miles near that project. It's different now, but in those days, nobody was around. And the Coastal Commission said, well, this is like Los Angeles, Malibu, and everybody's cheek to jowl on Malibu, and we need access to the beach. And the Supreme Court says, no, there's no nexus. There's no connection in Ventura County. There's no need for the public to have access, for you to dedicate a pedestrian access to the beach, because they can just walk right down the beach anyway. The other case is Dolan, and that's up in Oregon, and that was a case that said that this plumbing company wanted to pave its parking lot, and they needed some kind of a use permit or administrative use permit to do it, and the city of Tigard said that they had to dedicate a public greenway and a bike and pedestrian path, and in exchange for the permit. And they said, well, the bike and the pedestrian pathway the greenbelt doesn't really have much to do with our parking lot. It's the same parking lot before as it was afterwards. We just repaved our parking lot. It's a little nicer, but it's the same parking lot. So why do we have to put a greenbelt in? The court said, you're right, you don't. And they ended up not having to do that. So that was the nexus case. So they always talk about proportionality and nexus in the conditions. So when you see the conditions, you can't go too crazy with these conditions because you have Nolan and Dolan. That got expanded in 2013 by a case called Kuntz, another California Supreme Court. This is California, actually, it's a U.S. Supreme Court case. And they said Kuntz had 11 acres down in Florida, and he wanted to develop 3.7 acres of it for whatever. And the water district that was had a right to approve his development permit said that he had to reduce his 3.7 acre proposal to 1 acre, and he had to pay for improvements to an unrelated property nearby before he could use his 3.7 acres that he had offered to give up 11. So that Kuntz stands for two rules. First is that this was the first case where the local government imposing money as a condition was deemed to be a unlawful finding or taking. And the second thing, that he could sue them even though his permit was denied. Usually the project was approved, and then he sued because they had this unreasonable. That's Kuntz. So effective condition has to contain who has to do whatever it is that's supposed to be done, what exactly is supposed to be done, when is it supposed to be done, is it a condition concurrent, prior to, afterwards, and why is it? That's the nexus condition. And so we've got Sunshine Vista, and they have a mitigation monitoring plan, and let's see, this was they had a condition regarding affordable housing. They said the applicant shall execute an affordable housing agreement approved by the City Council in accordance with the legislative act of the Chapter 14-16 of the Code, and reserve affordable units, and the affordable housing agreement shall be executed before. So there's a timing thing, what it is, when it has to happen, what exactly it is, and who's imposing it. That's the city. That's an example of a condition. I think this is the last one, is an example, again, in Sunshine Vista, of a condition. Applicant must submit a fencing plan and get it approved by Susie before issuance of a building permit. So there's a timing of it. We don't want them building everything and then saying, oh, by the way, I forgot about the fence. They describe the type of fence it can be and where it can be, and they have enough detail there so everybody knows what's going on. So in summary, second to last slide, second summary, we talked about legislation, that's a zoning code, and judging, that's your use permit. Talked about basic parliamentary procedure. We had a good discussion about the motions and motions to amend and substitute motions. We talked about due process, bias, ex parte communications. We talked about findings, and we talked about conditions. And I like this slide. It's you know, it never ends. Often when you think you're at the end of something like we are right now, you're really not. You're at the beginning of something else, because you now, and they have to go out and apply all this, and you have to do it all the time. So I'm happy to answer any questions, but that concludes my my talk, and I appreciate everybody being so attentive and having such good questions. So thank you very much.
I just have one quick one. Thank you first, Alan. That was great tonight. I've done this for quite a few years, and I'm embarrassed to say how much I learned tonight. So the question that I have is on the findings. I would assume that in order to reject a project, we would need the same findings in reverse, correct?
You may be that you cannot make the finding. It wouldn't be that it can't happen. It may be that you well, Susie's probably got an example, but let's use the finding of the affordable housing that was a finding.
The condition.
It was a condition. So the finding might be that the project was not compatible with the neighborhood. It was maybe the project was an 8-story building with no parking. That would not be, couldn't make a finding for your, in a variety of reasons.
How about this, like on Sun Vista? So a lot of the complaints were traffic. You have a legitimate traffic study saying that that's not an issue. So if the council had decided to reject that project based on the fact that the neighborhood complained about the traffic, how would one do that if your findings show that the traffic is not an issue? I guess that's the kind of thing I'm talking about.
Would,
you have to prove your case almost, is
so
what you're
that would
saying.
be Lisa coming in if the council did that and saying, hey, you know, you can't, the finding was there, the facts were there to support the finding. They challenge it that way.
If you don't have the
Challenge.
findings, right?
Yeah. So let me kind of rephrase this. Let's say we've got a project that staff brings to Planning Commission and we're recommending approval, and findings could possibly be made against the project. At that point, would the best thing, but we haven't made any. We have not prepared findings to deny the project, but that's what Planning Commission, the majority of Planning Commission indicates that they want to do. Would at that time it be prudent for the chair to recommend that we continue the item and then have staff bring back?
Excellent question. That's an excellent question. And what should happen if the commission in its meeting feels that it cannot make those findings is to close the public hearing, continue it till a date certain. It's a motion to continue to a date certain, and then bring it back with staff making findings consistent with the commission's or the council's discussion and direction. It's a very good question.
Thank you.
Thank you.
Any other questions or clarification? That was highly informative.
Good, I'm glad.
Really appreciate you being here.
Good.
So thank you, yes.
Thank you. Thank you for the
We will
invitation.
move on, wait, what? Oh, are we making motions? We'll move on to, I know, really. Let's practice. Ooh.
We want to leave, don't make any
Well, we can practice here. Here we go. Item number 4, consent agenda. Do we have, yeah, didn't we?
Did we approve the minutes?
No,
Did
we
have
haven't
it?
done that yet.
Thank
so
you,
that's what I'm
Alan.
thinking.
Thank you.
That's what I'm, so do we have a motion to approve the minutes from the June meeting? So moved by Commissioner Sarmiento.
I'll
Do
second.
Okay, and seconded by Commissioner Jones. Do we have what's the other kind of motion here? No.
Can I amend? No.
Yeah, can you
I'm
amend?
sorry.
That's exactly what I was asking. I'm looking that up. Yeah, good. Would you like to amend that?
We can.
Yeah, we can have roll call, I think, on that one.
Dana? Yes. Jones?
Yes.
Sarmiento?
Yes.
Beach? Olson?
Yes.
Rivera? Cammer?
Yes. Moving on, thank you, Deborah. Moving on to item number 5, report of the secretary. Do we have things to report?
I haven't prepared anything for tonight.
That's okay.
Coming up.
How the beer compared to what we voted for.
Oh my gosh, well, it was a slightly longer meeting. Honestly, I would have to go back and look at my notes on the brew pub because I was so focused on Sunshine Vista. Okay, you've got it.
Well, keep talking for a second.
Okay.
I'll look it up.
So Sunshine Vista obviously was finally approved at about 1:20 in the morning, which is exciting. And we dropped off the notice of determination for the EIR today at the county, which, as Alan was mentioning, starts the 30-day challenge period for the EIR. And I know the developers are already shifting gears to begin their environmental grading and working with our building division to get their plans in for the actual development.
And then the brew pubs, the closing times are 11 p.m. on Friday and Saturday, and then Sunday through Thursday, 10 p.m. And then there's still 5 licenses available, and then the special use permit is good for 20 years.
There were a lot of friendly amendments going back and forth on that one.
It got a little bit confusing.
Well, but they actually did the thing where there was a motion made, and then someone seconded it, and they voted it down.
Yes.
And then another motion was made, and that one passed.
Educational experience. No, it's actually good to have the other experience where we didn't do it right because we could refer to something that we had done and then think about how it could have been done.
And now we know. Now we know, yes.
What's coming up? Anything cool that you can talk about or want to talk about?
October. Well, let's see, maybe we might have the alcohol use permit that we've been trying to bring to Planning Commission for 3 or 4 months up here, but they've got some reservations as to whether they need a use permit or not, so we're dealing with their legal team. Maybe we'll get there. We are working on, we have a redevelopment agency-owned property out at 36 Airport Road. It's a little less than an acre. It was bought in 2003 as part of the youth build, or to be part of the youth build project, which, you know, is teaching high school kids how to build. That died. And since the redevelopment agency disbanded, we have to sell all of our redevelopment agency parcels. So we are negotiating with Habitat for Humanity to transfer the property to them to build affordable units. And that actually has to come to you to determine whether it is consistent with our general plan or not. So that's slated to come in October. But yeah, it's kind of quiet. Knock on wood.
With a few months ago, there was a man who had his license, or his permit had expired for building.
Technology Drive. Yeah,
Yes.
I was wondering
Yeah,
about that one
West
too, because I
Eight.
pass it pretty often.
Right.
Yeah.
What's up with
Below the hospital.
that? Yeah.
Yes.
They have hired finally an environmental consultant to help them through the process to get their permit from the water board. So it looks like they will probably have building permit application in this fall.
And is that within the time frame?
Yes, they have, council gave them till the end of the year. Yeah, so yeah, we'll see if it actually happens or not. There's always, you approve a development and, yeah.
That's all we could do.
Exactly.
And then the housing on Marin and the housing on Airport, are there updates on those two?
Airport, they've actually asked for an extension on that, so that's going to be going to council in the next few months. But Marin Street, work has restarted just in the last, week or so. They have to do some off-site improvements, and it's underway, so they're moving.
I think they outdid their
Yeah. Too many projects, not enough time.
Are we going to have
Yeah.
any more cell towers coming our way?
There are none on the horizon. I can knock on wood. Yes.
You don't want any
Yeah.
of those when you're
Yeah.
running for office.
Oh, yeah, that's right.
You don't want those.
That's right.
Yeah,
I
that's
forgot.
not fun. But yeah, there's nothing really. We are. I could say we are interviewing consultant teams for the downtown specific plan this Friday. So that's exciting. And then we also have to apply for some grant funding so we can actually pay them to do the work once we hire them. But yeah, so that's moving along. And that's going to take a significant amount of time in the next 2 years for staff to work
The
on.
original type of thing where you're talking about islands and maybe
It's discussion of traffic and walkability and multimodal transportation connecting to the future rail corridor, increasing density in the downtown, design guidelines, looking at a non-displacement strategy, economic strategy, market feasibility, market analysis. So it's everything in the kitchen sink in the downtown. So, but exciting. So, yeah.
Other questions, comments? Meeting is adjourned. I don't have my theme. Where'd you go? I know, it's gone.